Let me start by congratulating all of us here on very successful landing of Chandrayaan 3 near the south pole of the moon. Apparently, we are not only making the mark on this world, but even beyond. One of the benefits of having to talk after, esteemed panelist is that I can be shocked because most of the points are already covered. And I'll try to be very short and try and give you a very different perspective on 2 or 3 aspects that I feel are very critical as we move forward. I'll share my thoughts based on my experience in global field. I've been working in the global area for almost 15 years and almost the same time in India. So I'll try and share those experiences which are based on my own working experience. But before that, let me make a disclaimer that these views are all my personal views, not of my organization. Before sharing my views on how we can make our economy 5 trillion and more from the lens of a corporate lawyer, it is also important to see how far we have traveled or how far we have actually reached. Let me share a few important initiatives undertaken by the government. Of course, this government and previous governments taken together. 1,500 laws were repealed by the government in recent past. And as corporate lawyers, most of us would realize that that makes our life a little simpler. Right? These are laws that were repealed by the government. There are 8 key initiatives that I would want to share with you. Some of them Dave has already mentioned, but I will reinforce them in terms of initiatives that the governments have taken so far, which have helped the economies to grow and Indian economy to grow. First is the introduction of GST law, as we all know, in 2017, has had a very huge impact. E-governance and digitization drive of the government. New insolvency code that was brought in 2016 and 17. Radical changes in the FDI, particularly in the retail sector. Tremendous push on infrastructure that we see now. Push on Make in India that we see. Manufacturing in India. Push for renewable green energy. And last but not the least, focus on compliances. I think new regulators have come in and there's a clear focus on the compliances. These are very excellent initiatives. And these have helped push India's economy to number 5 position today with 3.75 trillion in GDP. However, we must acknowledge that what has brought us here may not take us to 5 trillion and beyond. I'll make a few suggestions on what we can do to improve our speed of growth. And primarily, I'll focus on issues that an entrepreneur feels and gets while doing business in India. First and foremost, we've been all thinking about opportunity that we have gotten at this stage as China plus 1. There's a lot of discussion on India being the beneficiary of China plus 1 strategies of multinational corporations. In my humble view, we can do much more. They pointed out 3 Ds that the Honorable Prime Minister has already spoken about: demography, democracy, and the diversity, which is very, very critical. How can we convert China plus 1 to become India plus 1, where India becomes the key investment destination and other countries can be the backup option? So how do we convert China plus one to India plus one. And these are the issues, if we tackle them well, I think we will be able to achieve our objective. First issue I would point out is more certainty in enforcement of contracts in India. We all know contracts are the lifeblood of an enterprise. We also know businesses don't like unpredictability. They want predictability. There's an expectation when there's a dispute that these disputes will be resolved quickly and in a manner that is predictable. If we put our hands on our heart, can we say that in India we can resolve disputes in a short time? I don't think so. Any disputes that goes to court takes at least 10 to 20 years to resolve. Even arbitration takes a long time to resolve in India. So certainly there's a lot of scope to improve there. We must bring in reforms in the area of contracts law. And we all know that the current Indian contract law is a legacy of our colonial era. We must reform the current Indian Contracts Act, bring in more best practices from around the world, particularly on how we manage damages and how we calculate damages when there is a breach of contract. So in US, for example, there is a practice that is being followed where there is a pre-litigation mediation. And the way you handle that mediation as a litigant will determine whether you will bear the cost of the litigation or not. If you are unreasonable in the mediation sessions, you can end up actually paying the cost of the litigation. So certainly I think these are the areas that we all should look at and see how we can bring in best practices on contracts law in India. The second point on contracts. Most of the contracts with the government are very one-sided contracts. These are all templatized contracts. We are asked to sign on the dotted lines. There is no negotiation that happens. You either sign it or leave it. And what happens? Most of the businesses end up signing the contract, and then when there's a dispute, they look to resolve that dispute in a way that is not helpful to anyone, including the courts. You will be surprised to know that in Australia there is a process by which government contracts, certain government contracts, there's an individual person appointed, independent person appointed to observe how government contracts are negotiated, not to protect the government, but to protect the other party, so that the terms of the contract are fair to the other party. The third point I want to make on the contract, which also, by the way, is relevant for certain policies that are implemented by the government, which are retroactive in terms of penalty, damages, and interest. I think we have clarified in the law relating to taxes that there should not be a retrospective taxes, but there is a lot of opportunity to actually clarify this in policies and in contracts. Government should actually ensure that no contract, no policy should operate retrospectively to the disadvantage of the business. So that would be my third suggestion. The fourth one on alternative dispute resolution. We all know ADR is important, and we have all seen recently mediation law coming into force. But I am for the one in favor of mandatory mediation, not voluntary mediation. A pre-litigation mediation which is mandatory and which should be the litigant who is acting unreasonable in the mediation should end up paying the cost of the litigation. That's the best way to resolve a lot of litigations through mediation. Plus, there are many arbitration awards which today are being subject to litigation based on public policy. I think that public policy is widely being used, unquote, misused in the court of law by the litigants. I think that needs a relook at it. I'm happy to note what Mr. Viswanathan just now mentioned, that Mr. Prime Minister is also relooking at the entire application law. How can we implement, or how can we improve the functioning of the arbitration in India? So with that, I will close my session. These were very pointed and very few suggestions that I had, particularly on contract and how we can focus on contract law to make sure that there is more certainty in the businesses when they are executing a contract. Happy to answer any question if there is a time left. But thank you for listening to me patiently. I suggest that you have a great conclave. Thank you.